Welcome, everybody, to the first Constitutional Roundtable from 2025. It's great to see everybody here. It's a testament to our speaker, like we had students who were first last term here, or last week here, we also have on Thursday a book launch, which will be a consideration of Margot can hold up the book there, the Mitigating the Scholar book that we are talking about on Thursday. Before I introduce the speaker, I also want to introduce the latest member of the Asper Centre team, Margot. It's recently started last week as the Centre's research assistant. And welcome Rob to the faculty and to our small but mighty team at the Asper Centre. So Margot Young is a professor in the Allard School of Law, University of British Columbia. Her scholarship and teaching focus on the intersection of social justice and human rights, including housing, poverty, social citizenship, equality rights, and environmental justice. And I'm going to end her bio there. She said, keep it brief. But she was a very important contributor to our book that we are launching later this week, Mitigating Equality. And it's my pleasure to have her here speaking before our Constitutional Roundtable.
Well, thank you, Cheryl. It's a real pleasure to be here to see so many faces I've known for a while and some students from my class last week. Really great. I appreciate you coming. I want to begin by just acknowledging the land on which the University of Toronto sits, that for thousands of years, it's been the traditional land of the Huron-Wendat, the Seneca, and Mississaugas that we credit. And I'm grateful for the diverse Indigenous people who have shepherded this land and whose presence marks this territory on which we now gather. So let me begin. I have a sort of version, a bit changed, but very much the same actually, of the chapter that's in this book that we launched on Thursday. And I want to begin by noting that equality jurisprudence under section 15 of the Charter of Rights and Freedoms has tread a rocky road. That key decisions issued from the Supreme Court of Canada that seemingly set a clear path ahead only to be diverted by the next major case. And we're in such a moment now. The 2020 decision in Fraser in Canada was, and we've got just this well here, to the canon of equality rights jurisprudence, but it itself followed a fractious time on equality issues at the court. And then 2 years later, with the release of R and Sharma, section 15 analysis is sounding off course again. And the judicial authors of the minority judgments in Fraser, joined by two judgments from the majority, have come back in Sharma. And the equality claim in Sharma goes down in a judgment thick with the indicia of formal equality. And most offensively, this turnabout takes place in a case where the equality harm that the claimant, an Indigenous woman, faces cannot be started. It's a toxic mix of racism, sexism, and secular colonialism. So when we talk today, I'm setting out to identify some resurgent concepts in the Sharma majority judgments, concepts that to a one are destructive when fully leveraged of substantive equality. So I'm going to call these zombie concepts. These are notions that refuse to die despite being long dismissed by many judges and most commentators. They are the undead of equality doctrine, and they ensure that charter rights repeatedly falter, sabotage to result in indefeasible promise of transformative equality. Now, the Sharma dissent prefigures my argument. That is, it actually anticipates what I want to say, albeit in different words. The dissent states, and I quote, recently rejected arguments lend credence to the concern that equality claimants must, with each new case, stand ready to defend the exact gains that have been won multiple times in the past. So this is a quote itself quoting a commentator, but it captures the catalyst for my turn to zombies, and I take out this sort of disruptive paradox of zombie, which is the plural of zombie apparently. And these are creatures that are neither truly dead nor alive. I take out this term as tactic for examining how key destructive concepts lurch from one equality judgment to another. And zombies have, as the author of this social theory article, a zombie manifesto, as these authors tell us, zombies have persistent cultural currency and many functions. But I'm going to use the idea to code equality doctrinal elaborations that are unworthy of the life that the Sharma majority gives them, and that they are to blame for the jurisprudential restlessness, a quote from another commentator, that the Section 15 law, case law, demonstrates. So I also want to say that the fact that these zombie concepts that are so strong in a case where the equality part of that issue is so obvious, both individually for the claimant and systemically, that fact is not merely ironic. I'm hoping that it will in fact reveal some of the challenges of seeking transformative social justice through equality rights. And I'm going to trace that in the Sharma majority 3 concerns, the ones I'm calling zombie concepts, and they are causation, negative rights, and arbitrariness. These stop equality law, and I use the device of the zombie metaphor to map their problematic content of charter equality jurisprudence. And I really have to take myself in hand because I could just go on and on riffing on what terms could I use to talk about zombies and law. But in the conclusion, I'm going to leave behind the zombie metaphor to engage more directly with what they might be placeholders for. I'm going to look at the specter of judicial activism, which is a related monster. And I'm going to look at whether it's simply a sort of separation of powers gone awry that counts for the Sharma majority, but maybe something else as well. So let me just say first a few words about Sharma. Cheyenne Sharma is an Indigenous woman who pled guilty to charges under the Controlled Drug and Substance Act in 2015. She imported 20 kilograms, or 2 kilograms, sorry, of cocaine when her partner offered her $20,000 to bring the suitcase into Canada. She was facing eviction, single mom. She sought a conditional sentence that, if granted, would have allowed her to serve her time in the community rather than jail. But amendments in 2012 had removed the option of conditional sentences for the particular offense of which she was convicted. And Sharma claims that her ineligibility for the conditional sentence disproportionately affects her as an Indigenous woman. And this is reflective, she argues, of the impact and the rate of incarceration on Indigenous women. So her Section 15(1) claim is an adverse effects claim, a facially neutral law, sentencing reform disproportionately disadvantaged her on the basis of race. Sharma then is an adverse effects. And there's a lot of theorizing that continues to go on about the moral or political concerns that animate indirect as opposed to direct discrimination. And Canadian courts have largely skipped this discussion, although I know, Justice Isabella, you cite a collection of articles about moral foundations of indirect discrimination in your Fraser judgment, I think it is. But I'm also going to skip that discussion, but I'll note that adverse effects discrimination extends the reach of equality law, but it's not without controversy. So Ms. Sharma's circumstances then were stark and distressing. The dissent gives a very important overview of her personal history, the larger historic, systemic, and institutional context of the case that are shaped by the history of colonialism, displacement, and residential schools, and of course, higher levels of incarceration for Aboriginal people. That's a quote, a condensed quote from the dissent. But then we can say then that the context of Sharma really seems over-determined. I keep repeating this point because it's an important one. Seems over-determined in favor of the equality claim, and consequently, one would think ground too hallowed for zombie resurgence. And moreover, equality and reconciliation should pull in the same direction. Sharma presents an opportunity to demonstrate this, to ensure that Section 15 is responsive to colonialism, historic and current ongoing injustices. But the majority decision declines this opportunity. Justices Brown and Margot give virtually no significance to state responsibility for both the over-incarceration of Indigenous women and the damage that incarceration itself wreaks on Indigenous women. It's a little about the life circumstances of the claimant, which are so deeply shaped by the colonialism of the Canadian settler state. So let me turn now and talk about the central conceit of the paper. The majority decision in rejecting Ms. Sharma's equality claim relies on zombie concepts. And the metaphor of the zombies is useful here, I hope. Disgraced concepts resurface with regularity, ensuring that the jurisprudence remains unstable and ultimately unsatisfactory. But what do I mean by the notion of zombies? And I handed around, read quite a bit of stuff about zombies and saw that, and here I've got a raft of quotes about zombies, that zombies are described as culturally promiscuous, undead colonial constructs. Some histories of the concept trace it to Haitian folklore about the reanimation of the dead to labor in the fields with associations to slavery and to slave rebellion. It is, I'm told by these references, a figure with multiple valences and consequently convenient and really familiar boogeyman. The Zombie Manifesto, which is a sort of well-known social theory article about zombies, tells us that zombies are everywhere. So of course, I know we see them in film and fiction, but if you look to cognitive science, to neuroscience, to computer science, even to the natural world, where we hear about zombie ants, the concept is prevalent. They are, here's a quote, an ever-evolving metaphorical vehicle, undead chameleons, that, my words, lumber from context to context. So why not use it in law? And indeed, the notion of legal zombies is not new, particularly in the United States. Different strands of legal scholarship take up that concept. For example, the term is used to refer to statutory remains, laws that, despite having been deemed unconstitutionally invalid by a court, are left on the books only to be resurrected when the case law shifts. And we see that with some of the state laws after Dodds. They were in constitutional law after Dodds, so now that as prohibitions against abortion. Now, theorists describe zombies as haunted objects. That by haunted, they mean they have materiality in the body. It's a rotting, diseased one with lots of saliva, the literature tells us, but also symbolic presence, and this is the haunted feature. The ideas of conflicts that animate them also haunt thought. And I think equality concepts have the same tension. Their impact on equality law actually results in real and embodied consequences for equality claimants, because the sentencing judge denied the charter claim or the conditional sentence. Shan Sharma served her sentence in prison, not in her community. But these concepts of cause, negative rights, arbitrariness, also caught analysis, shaping thought, and they're present even in cases where equality rights triumph. So, for post-humanist theorists, zombies standing for a myriad of cultural anxieties. They cannibalize opposition, they provoke fear, and they encode dis-ease. They are decaying threats to civilization in so many of the cultural contexts in which they appear. Now, in equality law, I want to argue these zombie concepts are already half-destroyed artifacts that shamble on, but that they're menacing outsiders that come from within. And that's a key piece of my argument, and you can ask me if I make it successfully, but I'll say more about that in a moment. Zombies in culture, think of films, are also boundary figures. They occupy the border between the living and the dead, but I think they're also boundary figures, these concepts in equality law, because they're policing a line between formal and substantive equality. Now, ultimately, I'm going to link these zombie concepts to anxiety, to judicial fear of courts, and rights run amok. But I'll talk more about that later. So what's a zombie concept in law? I have three general features I assigned to me. First, a concept becomes a zombie when it's already been refuted by both judicial precedent and scholarly comment, and yet it keeps coming back. Second, a concept is a zombie concept when it's intelligible from within the history of equality rights, but at the same time threatens to destroy, often on equality's own terms, core potential of these rights. And so they're destructive of equality from within. They are paratitoids. Brenda told me I was going overboard by pulling this one out, but paratitoids. I think that's how you say it. Yeah, I should look that up. Anyway, I think it's paradactyloids. They're parasites that kill their host. And okay, Brenda, maybe I've got too many metaphors in play here. But this bit that they kill from within, that's the trickiest part of my argument, actually. I'd love to hear from you I'm successful in being a little bit convincing. And then finally, zombie concepts are those concepts that scare equality analysis beyond reach of substantive equality back into the grip of individualistic formal equality that was rejected off the start, although somewhat ambiguously, by the court in its first equality case, and it was in the Law Society of British Columbia. Okay, zombies in Sharma. Justices Brown and Margot are quick to begin by stating that the test for section 15(1) from the Fraser majority is the one they use. So they reference it, but then very quickly they go on to say it's not clear. And in offering clarification, the judges summon the zombie concepts of, as I've said, causation, arbitrariness, and negative obligation to essentially, despite the claim to the contrary, rewrite and recast the Fraser test. Now, the list of concepts I've got here could be longer, but these are the concepts that I think really scaffold the majority decision in Sharma. So I'm going to provide an overview of why they're problematic, how they actually are also a piece of past equality analysis, and what they achieve for majority judges who help it on defeating the Sharma's claim. Each of these notions in turn touch on something that's sensible, but the insight they might lend on occasion is distorted by an exaggerative and destructive importance that I think. So let's talk first, or let me talk first about causation, and it's really an exemplary zombie concept. I've written a lot about it in other articles, but we can see that it remains a constant manifestation in government and in judicial arguments about other charter rights as well, section 7 in particular. Reference to the notion in Sharma recalls past judgments. They talk about Justice Savella's majority decision in Fraser, setting it up for them. And here's the thing, the idea of causation makes simple sense. Equality is a comparative concept. That's actually its strength. That's why it identifies harms that section 7 can't contemplate, the comparative quality. But that means that an equality inquiry has to be grounded in showing difference in between a claimant group and some other group that connects with some sort of government failure or action. So here's the test. The claimant must show two things. First, establish a distinction based on an enumerated or unenumerated ground here, say race. And secondly, that distinction imposes a burden, denies a benefit that has the effect of reinforcing, perpetuating, or exacerbating disadvantage. So sort of conflated the two steps, but it's a burdensome or benefit denying distinction on the basis of a recognized ground, enumerated or unenumerated, and does that distinction reinforce, perpetuate, or exacerbate disadvantage? Well-established two-stage analysis, setting up the distinction between what is different treatment and what is discriminatory treatment. Now, the majority is right that disparate impact discrimination sets a tougher task. One doesn't have recourse to a legislative enactment on the face of which the differential treatment is clear, nor, as Justice Savella states in Tekotak, is it a mere web of instinct that is enough to ground disparate impact. The notion of causation, therefore, belies this first stage. But too rigid and demanding a demonstration of it can distort what substantive equality must make visible, the contextual common sense appreciation of disparity. Now, the majority in Sharma finds that there's an absence of statistically grounded disparity. There's nothing that shows that the legislative distinction has caused a disproportionate impact, and that's down of the claim. And interestingly, the majority credits Justice Isabella's judgment in Fraser with this application of causation, but that credit is disingenuous. Justice Isabella allows for a range of evidence. She warns against too rigid rules for evidence, and her concluding statement is clear here in the quoting. Both evidence of statistical disparity and of broader group disadvantage may demonstrate disproportionate impact, but neither is mandatory, and their significance will vary depending on the case. So a strict causation requirement sets up equality law to be non-responsive to those who most need it. Individuals whose disadvantage is most easily recognized and measured tend not to be those who occupy the most marginalized and diverse groups. The more complex or intersectional the identity of a claimant group is, the more likely the inequality they bring to court will require of adverse effects of discrimination. And the less likely it is that that adverse impact will lend itself to statistically accessible capture, to statistical capture, because intersectional claims are more nuanced, marginal groups are less examined. So the deep inequalities of Canadian society, the broader intersections of race, of gender, economic hardship, institutional and personal legacies of settler colonialism, basically this Sharma's case, those are going to be difficult to capture if you have a really strict requirement, particularly a statistical requirement of causation. So that's sort of the sense and then the ill use to which the nation is put. I'm going to move on to the second concept, arbitrariness. Now, arbitrariness is a troublesome concept, but it's a concept. It's a zombie with deep ancestry. It reaches back to the very first equality case where Justice McIntyre writes, and here I'm quoting, distinctions based on personal characteristics will rarely escape the charge of discrimination, while those based on an individual's merit and capacities will rarely be so classed. Arbitrariness continues. I'm going to unpack that in a bit, but that's the location of if it's based on personal characteristics, but it's based on merit, capacity, or capabilities, it's not going to be an equality issue. So we see it set up for a kind of arbitrariness standard, and it remains to be a concern in the case law that follows. So Justice Isabella in Taputat relies on her earlier judgment in Quebec and A to assert that discriminatory distinctions are those that they have the effect of perpetuating arbitrary disadvantage. Arbitrariness also invokes the idea of stereotypes, a term that in equality jurisprudence signals judgment about individuals or a group that is unanchored in their actual attributes. We need to go back to that last bit of the quote from Dixon in Andrews. But McIntyre and Andrews. Unacknowledged in McIntyre's statement in Andrews is that the assumptions of merit and capacity reflect histories of deep systemic inequality. This is not something new to say. So today's condemned stereotypes were yesterday's common sense. And at that moment in Justice McIntyre's judgment, his thrust to substantive equality, when he talks about merit, capacity, distinctions based on those factors, is going to be unproblematic. At that moment, his thrust to substantive equality folds back into a context of its formal equality. So we do, however, want to say that as with causation, arbitrariness is sometimes a useful feature of discrimination. Imposition of burdens or denial of benefits for select groups with a problematic justification is a problem, is concerning, as Justice McIntyre observes in Andrews. Substantive equality rests on the idea that not every difference in treatment will result in inequality, and that identical treatment may sometimes produce serious inequality. And so there has to be some way to assess when differential treatment or the same treatment produces either equality or inequality. And it's clear that irrational, irrelevant distinctions drawn by state action that distinguish between groups should attract critical attention. So like causation, the notion of arbitrariness also seduces. But excusing government action from the charge of discrimination if that action does not appear to be arbitrary paints with too broad a brush. It risks reliance about assumptions about complaining groups' characteristics that, as history shows us, can themselves be shaped by discriminatory assumptions and, moreover, sometimes distinctions that are not arbitrary may nonetheless perpetuate disadvantage in a discriminatory way. So, Justices Brown and Rowe, they're not attentive to the circumstances of Ms. Sharma and how removal of one option of conditional sentence affects her and other Indigenous offenders in the context of colonialism and over incarceration. Ignore this context, that would actually give them a more critical take on the relevance of arbitrariness. Rather, they look simply to the current post-amendment sentencing regime to disqualify her claim. And Justice Isabella's Fraser opinion is again sourced for this focus on arbitrariness, but her discussion is given a creative read. Fraser's focus on the circumstances of women in the job sharing program is a model of looking to context for the wider set of interests that inform the claimant's circumstances. Justice Brown and Rowe's reference to Whitler and Canada, where consideration of the full legislative regime decided the discrimination issue, simply allows them to argue then that the ameliorative effect of the law on others and the multiplicity of interests, I'm quoting from them, that it attempts to balance will also color the discrimination analysis, and it covers it as invisible. There's no discrimination. So they neglect the specific issue, the specific harms of an issue. They ignore Justice Isabella's warning in the Central decision to not sanitize the discriminatory impact, and they're deeply sympathetic to the multifaceted and complex policy considerations facing government, not so much, however, to the plight of Indigenous women in Canada's criminal law system. So the Sharma majority uses this notion of arbitrariness to further reject her claim. It's not part of the first part of the inquiry, so it serves as a kind of comment in obiter, but the discussion is evocative, albeit not determinative, and we see that the concept of arbitrariness is once again revived to live on as a potential spoiler of equality sensibility. Last one, negative obligation. Let's check that one. Okay. It's not surprising to see an insistence on negative obligation in the majority Sharma decision. This is in fact the most persistent and popular zone in Canadian charter law. And this is despite the fact that in Andrews, Justice McIntyre said that there is a positive right to equality of both substance and administration of the law. So this zombie has conflicted parentage. Justices Brown and Rowe are adamant that Section 15 does not impose a general causative obligation. They elaborate that simply leaving a claimant in the same situation cannot be a charter infringement. But you know, and this is what the dissent captures. Sharma invokes a situation, sentencing in the criminal law system, that has already the government's fingerprints all over it. It is an area deeply defined by government action. And insistence that governments have only a negative obligation under Section 15 allows the causation question as well to forcefully defeat a discrimination claim. Without positive obligations under Section 15, where there's no clear evidence that the government caused the disproportionate effect, and the government is free simply to leave the inequality no matter how great it may be in place, according to the majority. And so there's an interesting way, I think, that these concepts work in sync, that they actually amplify and create conditions for each other in some way. And of course, I want to say that a conversation about positive obligations bears much more discussion, looking at commentary, and increasingly from the judiciary themselves, and some Supreme Court of Canada cases, also in the lower courts, that the distinction between causative and negative obligations really is neither logical nor useful in terms of deciding an equality or say a section 7 interest. But the notion of limiting equality rights to imposition of negative obligations alone was not without attraction for judges. Schooled at a time when it's common to worry about the legitimacy of an overactive court armed with a charter, understanding equality rights negatively puts a cap on what section 15 might require them to do. Okay, so do these criticisms matter, no matter how convincing they are? Maybe they're not convincing, but does critical doctrinal engagement have some meaningful way? So after all, you can't argue with zombies. They actually have to be pierced in the head with some special kind of iron sword. You can't argue with zombies, or in this case, you can't defeat zombie arguments by reason alone. Instead, when one observes this kind of forceful yet problematic judgment, it's important to ask what boils beneath the textual surface. Metaphors, by the way, are illuminating, but they ultimately wear thin. So their literalness, key to their effectiveness, offers too narrow a portion, that it hides some dimensions and overemphasizes others. And this is unavoidably true of my framing following jurisprudence in terms of the resilient but destructive zombies. The fit's not perfect, so I'm going to abandon the notion for much of the end of my paper, turning the idea of empty, soulless zombies on their head. I want to argue that there's something behind their multiple reappearances other than simply what is being filmed and with zombie ads, for example, this kind of mindless reproduction. So the question then is, what's at stake for the judges? Next, what's at stake for the judges in Sharma's majority? Why did Wagner and Moldaver jump ship from the Fraser majority, and Brown, Rowe, and Cote, Justices Brown, Rowe, and Cote never really on board? And so there are odd bits in this discussion that might be revealing. We see reference to the primacy of democratic legislative decision-making and choice. This echoes previous reasoning by the same judges in past cases where they urge equality points to take their cause to the polls. And backdrop to this set of concerns is, of course, the notion of the separation of powers. This principle provides a grammar of legitimation for every branch of government, and more specifically, for the context for discussions about what properly lies at the door of reviewing the courts. We've seen with the advent of the charter that the courts have increasingly had to toe a difficult line. They straddle an uncomfortable line. They must neither supplant the legislature nor abdicate their role in judicial review. And so from this perspective, the context of Sharma matters, but in different ways for the majority of dissenting judgments. For the dissent, it's the backdrop of colonialism and the history of Indigenous women in the criminal justice system that is telling this context grounds their finding of discrimination. But for the judges of the Sharma majority, it's a different contextual focus. They look at the adverse impact nature of the claim discrimination, and the remedial character of the sentencing option, conditional sentences that the impugned government action denies to Ms. Sharma. It's the government action at issue that's more complex. Repeal of a remedial benefit, that matters, and it's not simply institution of a burden. And by this I mean the sort of ameliorative fact, the notion of incrementalism, of leaving governments free to do partial but not full, and to rejig equality-focused activities is a common theme for these judges across their cases. So this legal and legislative context maybe explains the majority's reworking of the test from Fraser and Moldaver, justices, or Chief Justice Wagner and Justice Moldaver moved to join this majority. But I think there's also a broader policy-based concern. There's a lot of focus in the majority on the policy at issue, and one is tempted from another perspective to explore whether the concentration of zombie concepts is an instance of, here's another metaphor, extinction burst. This idea, this last gasp of a dying paradigm, as it were. So you've seen progress in judicial understandings, we've got enhanced judicial appreciation of social justice, of over incarceration, colonial injustice, gender equity, inequity in some cases. So maybe this judgment in the majority is simply a response to this, a kind of pushback. And this connects with another observation. Some of the judges who formed the Sharma majority across a range of cases and for a number of years have shown straightforward hostility to the animating spirit of substantive equality. The court's committed itself to a substantive equality frame from the very beginning case. It's reiterated in pretty much every section 15 case, but the Sharma majority is notably less wholehearted in its take-up. I said I was going to leave them, but I'm not. I'm going to go back to zombies for a moment. Zombies foreground. It said that zombies foreground commentary on historic systems of power and oppression. Specifically, literature says that they foreground commentary on the dominance of patriarchy. So they're not simply ravenous somnambulists, sleepwalkers, foretelling, if left unchecked, some nondescript monstrous future. In some cases, zombies actually feature as holders of this resistant kind of status quo. And the systems of justice and equality that deeply contour Cheyenne Sharma's section 15 case might be just that status quo, that these notions are here in aid of rendering invisible or non-equality info. So I'm going to conclude. The resilience of the zombie notion is on name, and the resurgence in Sharma asks us to think hard about judicial review, equality, and Canadian state. Ideas about causation, arbitrariness, and negative obligation, as they're deployed by the Sharma majority, are simply unlikely to shape a vision of section 15 that stands as a beacon of substantive equality. But it's also true that equality analysis is malleable, and there's no set of rules or staged process of interrogation of claims that will make a court's determination of section 15 determinate or safe from the kind of contamination that I hope I documented in the Sharma majority. And so let me go back to reference zombie fiction. In these tales of zombie invasion, it is vigilance and leadership that win the day and defeat the zombies. So maybe then, in the rather less dramatic context of academic commentary, we need equal alertness to the analytic threats that continue to persist in equality jurisprudence. Thanks.
Some time for questions. I'll be giving
Margot, that was so gorgeous. And I would like to stay all day and listen to more. And what a paper, I can't wait to read it. So I wanted to ask a question about how these zombie concepts can help us think about constitutional time. Something and I was reminded in your paper of Nietzsche's demon of eternal return and the way in which he sort of destroys our sensibilities around time by always coming and asking a question that we already thought we previously answered. So sort of all of our sensibilities of time get destroyed in the same way that these zombie concepts are destroying our understanding of time. Death loses all meaning when you can never die, for example. And I'm wondering if the impact of these zombie concepts is we get a certain timelessness that is pervading the logic of some thinkers about constitutional law, such that causation can never actually be a real question because the state always exists in the present and is responsible for things in historical time. The same way that questions of arbitrariness will always be combined to a certain presentism. A soullessness reminds me of the memoryless flying. Those seem to go hand in hand, which is once again inserted narrowing of time by the raising again of questions that we never answer because they've been answered.
Because we just keep answering.
We just don't have answers. And so I wonder if there's something about this concerted effort of maturity in Sharma to try and take the practice of constitutional law outside the time and limit the responsibility and limit the power of section 15, which is, I think, a concept that gains power through a broader understanding.
Yeah, so I'm gonna think more about this, so I'm not sure I'm gonna answer it and bang on. But I'm gonna figure it out, this because it's like, okay. A couple of thoughts. The first thing is that there is something eternal about having to answer the same question over and over again, or failing at the same question over and over again. And actually, I'm a zombie scholar, because I've written all about these concepts before, and then when I sat down to write about Sharma, I was like, I have nothing new to say. So this is kind of a product of, what does it mean to have nothing new to say as a critique? So I need to say we're yeah, but so I, one of my footnotes, I say, like, I'm a zombie as an academic as well. I just want to put that, I keep coming back, saying the same thing. But, so there is this sense of, there's something about progress isn't happening. And that is connected to time, but not in the way you describe it. But so I'm gonna have to think more about that. There's also something about not looking to the history, which is part of the broader context of colonialism and the way in which the criminal law system got to be the way it is with its impact on Indigenous peoples, but also in Indigenous women really acutely. And that's about time. There's sort of a timelessness, like it's all fresh now. We're gonna see this as not a kind of persistent, accumulative, historically explicable situation before us. But those are my thoughts. And do they like disrupt time? Do they skew our sense of it in other ways? I don't know. But I would say, so I want to say that these concepts are not, that they actually have a soul. And that's what I meant by turning zombie concepts on their head. That they're really about judicial anxieties around separation of powers and legitimacy, but they're also for these judges about what happens if you really go with substantive equality, because deep change is a feature of substantive equality in a way that our courts reach toward, but never quite get there. And that's a function game of what can you do with liberal rights in the context of a liberal charter in terms of trying to achieve transformation, but then also positive rights open up a real Pandora's box, and it's fair, I think, to engage with the conversation of the illogic, or at least the malleability of the distinction between positive and negative, like between private and public. But there's a kind of, there's a common sense utility, and it's not without meaning, although making it a determinative factor is problematic because it's indeterminate, it just isn't helpful, and we see it in reach all over the place where it's unacknowledged. But that kind of sort of acontextual snapshotness of these concepts definitely has something to do with this idea of time you're bringing in. I'm just not sure how I would play it out more, but it's really interesting. Thank you.
David, you're next.
Thank you, Mark. It was always insightful. It's nice to know you still list out.
Oh, well, I mean, how does one ever leave those behind where there's still substantive equality only peeking out at the edges?
So I was glad that you were thinking about the reasons Moldaver and Wagner switched sides from Fraser, were in the majority, to Sharma in the majority. So I'm wondering if you might just expand on your thoughts a little bit, because I wasn't sure exactly what you're saying. Is it that there's a separation of powers anxiety that helped to precipitate that switch in Sharma? Was it perhaps the negative obligation paradigm that was driving that?
Yeah.
Which was also, of course, in play in Fraser. I mean, Brown and Rowe wrote their dissents, precisely, well, in part, attacking the obligation of government to fulfill childcare.
Yeah.
Funding.
Yeah.
And so Wagner and Moldaver are on board in Fraser, but not on board regarding positive obligations in Sharma. And so I want to suggest to you that maybe there's a middle class bias at work.
Interesting. Because I would actually give, I mean, I think those might be features, but there were features in other cases where they actually were in the majority, which you noted. But there's another, I'm just trying to remember which of the pay equity cases.
They were, it wasn't the pay equity, Brown's analysis in Sharma mirrored his analysis in the both pay equity
Right.
cases. And then repeated it in Fraser, which led me for the first time in my judicial career to criticize a dissent. I never did that when I was in majority, or to criticize the majority when I was in dissent. I just disagreed. I was so pissed off that institutionally they just rejected the majority, which is something very interesting from your piece. What's missing is the institutional concept of ignoring precedent and then getting people to come along with you. Now, the case that's missing is CP. Between Fraser and Sharma was CP, which was a section 15 case about young offenders and whether or not it was a breach of section 15 to have, even though they were young offenders, to deny them
The right to appeal.
the right to appeal, which is automatic if you're an adult. And the boys went with a different concept in section 15 there.
Right,
So they were starting, I think, you know, what people don't like to talk about is the fact that who the judges are make all the difference in the world. Their inclinations weren't comfortable with substantive equality. And once the room was free to go after, they did. But their instincts were never there.
right, and that's part of the soul that I want to give these zombies, a hostility to substantive equality.
It's not a hostility so much, although Brown's gay, and he's a friend, now this Scalia RBD thing is true. You can be very close with
Yeah.
people you run about. I love Russ Brown.
I'm actually friends with them too. He's a former student.
He's great.
Very lovely.
He pisses me off, but I really like him. But I think that in using activism, I worry about that because judicially I grew up resisting the label activism because we were actively increasing rights, and that's when they started screaming about judicial activism. So now we're getting it on the other side. So there's so much that's personal, I think, in these kinds of things, a lack of respect for institutional the trajectory in section 15 from Andrews through Whitner, which was the change, you know, getting rid of comparative groups, which other judges had clung to, and then finally getting to Fraser, but clearly resistance was lurking. I think it's a lack of understanding rather than hostility.
Well,
Just
that's
to be
interesting,
fair.
because I read it politically, not as a sort of a conceptual failure, I read it politically. That the kinds of things that substantive, and this is something in an answer, sort of comment in yours and answers to you. What I wanted to say is that the context that matters for the dissent in Sharma is this larger, historic, configured context of colonialism, racism, sex, and criminal justice system, for example. But the context, I think, that matters for the majority, and I read this in light of CP and who joined Brown.
Same team.
Yeah, same team. This is about an apparent benefit that's been constrained by the state. And it's part of what the concern was for Brown and Rowe and Cote in the pay equity cases as well. The government should be free to offer benefits as incremental or as impartial as they want. And there's this line that Brown has, we're not going to constitutionalize a particular program, which makes no sense. But I think it's about that context of positive ameliorative action. I'm not saying it's a section 52 program, that the government wants to do less perfectly or less fully.
I think in Brown's case, he is a libertarian. He is a intellectually consistent
Yeah.
libertarian. The state has no right. We don't do the positive. We drove a stake in the heart of positive negative rights after Bader. Right? We just thought it was stupid. And we didn't use it again, although except City of Toronto, that the same people would have it because of a view that the state should stay away, which simply works beautifully in civil liberties concepts and cannot work in human rights concepts. So they don't get, honestly, I say this with, I'm not gonna say great respect. I say this with some understanding that conversations about equality rights are not easy for people who are libertarian or private law focused.
I think that's exactly right. And that the notion of negative obligation is consistent with classical liberalism, which is actually defining paradigm of rights in the first place. And that, but the trick here is understanding that a profession of substantive equality, if not paired with a willingness to impose positive obligations, will never satisfy or meet substantive equality. And the commentators have been clear about that. So when I go to this judgment in Sharma and see the statement is, averring that 15 has no positive obligation, and I see it replicated in lower courts now, right? So the claims to environmental justice under equality rights and Section 7 rights, in some cases, like in the Mather case, the judge says, well, these are negative rights, so we're going to go ahead. In LaRose, the judge says this is a meaningless distinction, I'm not going to rely on it. The court has not yet communicated clearly to vote on the basis of what it says itself in the lower courts, that distinction is not useful, but other jurisdictions and commentators galore wax on and on with this. So I think you're right about Brown. I think it's an ideological perspective, which would be why I would say it's not a failure to understand. It's a way of framing the relationship between the state and the individual that has a particular ideological past to it. And that's the soul of these concepts. That's why these concepts come back, because they're useful to reinforce the idea that rights are just this white picket fence around doing nothing more.
They're also not very good on group rights. I mean, the individualism at the center of civil liberties rights.
That's a part of the classical liberalism that combines civil legalism. But I think it's what the claimants were asking to be done, that this was a state program that they wanted more of, is what informs this idea, this ultimately the judgment in the majority judgment in Sharma and why those two judges came over. And that's why I say the context matters, but in different ways. It's the context of the government action that's at issue, the idea that we're not going to force a constitutional standard on the government in this area, sort of the beneficial actions, whereas for the dissent, the context is just so thick with inequality that it can't not say. But that's my answer to your question. Maybe we danced around it, I think, or maybe it doesn't.
I don't want to monopolize the discussion, but institutional reality such does not explain what mayor's switch.
No, but that's another conversation.
That's what animates. That's partly why we're required to do this. Like, what are those two judges doing in the majority judgment, given the pay? What they really want, yeah. So other questions?
So Jean Christophe's next on the list for questions.
I think it's going to be a particular way my question would have been along the lines of the question that we asked, but she has a much better version of anything I could have come to try to get into their presentation. So these are the ones. So I'm wondering if the zombie concepts that you identify come from or flow from and other concepts that we don't have. Americans have a lot, and that kind of shaped the structure of their disagreement of their cases, which is starting slices.
Yeah.
So it seems that starting slices kind of marks at that point where those things are now dead. Just move on. We're elsewhere. We enter a new world, and it marks the difference between a concept that's alive or a concept that's dead. So my understanding of starting slices is really not only is it not the cases judges switch from and they refuse and they reuse those cases and cite them some dishonesty precisely because they don't have or they don't want to use the tools that they would have to say, oh, that was that, this is now we case from. So I'm wondering if is it so the reason why we have so many concepts is it because we don't have a strong doctrine of starting slices? Because we've moved away from that and we've refused the kind of binary alternative between living and dead doctrine. All doctrines are created equal. Some of them are a bit more likely than others, but they don't really lie. Sometimes we kind of tinker around and in our mind about this is the overloaded, which is another way we should put it forward. So I'm wondering if there's some kind of interaction with the zombie concepts and not having robust doctrines.
I think those are two stories, right? I think we can check. And that I'm using the notion of zombie concept. made up and just kind of was fun. But I wanted to capture something about the recurring nature. I mean, maybe I should say another story to tell about this is the fact that stare decisis, doesn't hold much water in the area of equality rights, and there's some reasons for that. I think I touched on those at the end. But I also think that stare decisis is always imperfectly realized because of the indeterminacy of language and ideas. And so this majority claims to be following Fraser. Of course, the dissent points out they're not, but there are always alternative ways to say you're telling the same thing. And so I'm not that concerned about what you call it, but you say this is a failure to actually cleave to what the court has said in past decisions, even if you were a loser at that moment. I mean, LaRue debated that, right? She had an alternative argument in dissent, and then she comes on board to law, right? Even though it's not completely what she wanted, it's got pieces of her, and that's kind of the collaborative crafting that functional courts do, maybe. But I still think there's something about it taking the form it does, right? They're not upfront about their failure to conform really obviously to past decisions and past frameworks. They employ these ideas as a kind of justification of the common sense of what they're doing to clarify. But yeah, I mean, so Justice Abella's comment and yours about stare decisis makes a lot of sense. And I wonder if it's just simply would be another way of telling the same story. And when you tell stories differently, they have different flavors, of course, as well.
There's also the history of equality. Section 15 is grappling with stare decisis. So it started with Andrews. It then went through the insular minority Americans. It landed in law with dignity. We changed it because of academic writing. There was no court decision we relied on to change it in CAP. It was all of it, and it was footnote. We put it in the footnote because there were too many to put in the text of just good academic writing saying this dignity test that you thought was good is really better. But what's important about this stare decisis trajectory in section 15 uniquely, if you look at it from 1989 to Fraser, it all went in one direction, and that was an increasing awareness that we should protect more. It was an inclusive trajectory. What's happening now with CP and Sharma is a different approach to stare decisis, not changing it with an understanding that we missed out on something we needed to add and build. It was, we gave too much away and now we're shrinking, much like dogs. That is never, that's new. That is a, I don't know whether you call that zombie or what, that's a new approach to constitutional interpretation of that.
You're right. But you know what, I would throw Gosselin in there. I think Gosselin was not a step forward. It was,
Okay.
It was a disturbing one,
Right.
But I understand the,
But overall,
the stream overall has been correction explicitly towards more substantive contextual and in some ways like the two-stage test that emerges so strongly in your judgment in Fraser. It looks to me a lot like how I read Andrews.
well,
To
just
tell you the truth.
I mean, they took my definition of discrimination and equality in Andrews, so I've always had an affection for it.
I think Andrews was kind of snake that eats its own tail a bit. This business of merit and capacity will be okay. I mean, but I did see Andrews as saying you first have differentiation on enumerated grounds, benefit burden, and then you have discrimination. So I see Fraser as the inheritor of the spirit in important ways.
And it's in Andrews, in the American system, is that every distinction is discrimination. They actually have a concept called positive and negative discrimination. And I have these debates with my colleagues in the States and say, how do you have positive discrimination is bad? Well, when every distinction is considered discriminatory, and then you have to justify it,
Yeah.
they don't get it.
But they missed like the insistence on intent, the failure to actually understand affirmative action as an equality
They
action.
don't understand equality. The 14th Amendment is is sameness, it's areas
There
of
is formal equality, but it's just to say that there is this stereo decisis problem for sure in the majority dissent.
Yeah.
In Sharma, sorry, the majority opinion in Sharma, and I just wanted to tell it as a tale of conceptual obdurateness of the zombie thing, but you could say they have no base, that they're just not right, that they're using the Fraser test and clarifying it. And, you know, these things have all gone by the way.
That's not what I'm saying.
Oh, that's not what you.
That's not what I'm saying.
Oh,
No. It was that, okay.
what were you, how did I miss what?
No. I was just wondering, the thing is that. I understand your criticism, which is a criticism of they're not following that, and they're not really following. Savage and phrase, but it just so happens that you don't have the final tools to explain that they're changing their mind, and that this precedent is not a good precedent. We get also another, in like, let's imagine an alternative constitutional universe where judges just change their minds after a couple of years and they decide that a precedent is not a good
But
precedent anymore.
the Supreme Court do that.
What?
The Supreme Court's done that quite recently. They did it in Carter, and they did it in Bedford, and they did it in.
But you don't.
The response, well, one could argue, they said now.
They said out of test.
I mean, in Carter, there's no.
They changed reference to crossable, yes,
In Carter.
There's a recognition that lower courts could consider alternative evidence, come to the conclusion, but the court doesn't say this was a wrong decision.
No, you said, what we said, Rodriguez is not the one.
Yeah, changing circumstances, new evidence, there's something different of a legal or, so internal or external. That allows us to see if the decision needs to be cited differently. And in the case that followed Bliss, Brooks. Almost said it was overturning Bliss, didn't quite clearly did. So there is some language there for changing your mind, but it has to have. It's not like all things are equal, but they're still gonna come to a different conclusion, right?
Brooks
Well,
was
this
a
is the
human
test,
rights
but yeah.
case,
That's right.
and that was Dick's, and it wasn't constitutional, but all of his jurisprudence, Brooks, Jansen.
Yeah.
Built the foundation for the section.
But some of the things he said in Brooks about distinctions
Yeah.
based on pregnancy and so on were clear refutations
They,
of the
You're right.
analysis.
you're,
Do we have any other questions?
I just wondered, oh, sorry, go
No,
ahead.
I had to wait.
Go ahead.
So, did you?
oh no, I'm just wondering.
Well, I'll try not to. So, I mean, I really appreciated your gesture to political. And it seems like kind of the story you're telling is somewhat kind of like full of these backlash. Right? There's like this expansion of quality, and now there's kind of like.
Well, that's the
Scat-
distinction versus idea that I feel very. It's like one of those things that I don't actually think that's what it is, but I'm good at.
Okay, so I think
You guys-
I was a little more sympathetic to that because I'm an American myself. I was always kind of paralyzed to looking what's going on in different jurisdictions. And one of the things I'm noticing / anxious about is that and about political, I want to actually use the zombie concept. I want to draw our attention to contemporary zombie media, you know, versus the like kind of the the original versus zombies in like the 70s and film like that. Right now, a lot of zombie film, especially literature, TV, is after it's been lost. Right, The Last of Us,
Yeah.
World War C, said, and Train to Busan, for example, from South Korea, in which zombies are like, you know, seen as some kind of epidemic or pandemic, right, spreads over, and it's an infection that can't be stopped. And I'm wondering if that's like reflecting this kind of precarity moment that we're in which we're worried that, you know, resources are obviously batting down the hatches.
Yeah.
Like, looking at climate, you know, change and things like that. Such that, you know, I think the gesture political makes a lot of sense, so I'm wondering in terms of like judicial discourse as a kind of public reasoning. How much it is dependent still on the instincts, intuition that there's enough resources to go around for this right, which is at least most facially distributed. Right, which is ensuring that the state is making sure that it's taken care of fairly. Is there a way to do this? I think just in terms of like, well, it's a battle between judges in terms of their perspectives, or is it dependence on a substrate of political economy And that there needs to be more dialogue, not just with legislature, but also with, I think, maybe a larger, more expansive grappling in terms of what we have to go around and it's out of it.
Well, so it's interesting, because I can see that in terms of a key feature of the kind of political discourse at the moment, and the assumptions that actually misinform that discourse. I don't have to translate it into judicial decisions right at this moment, but Rosie, you sound like
In
you.
green, the court said, cost is irrelevant.
Right.
And that is the philosophy that until now we've adopted. But I think you probably identified undercurrents that may be affecting the majority, something that maybe, I don't know.
There have always been.
But we never thought of it. It's a picture of people.
No, I'm enthusiastic to say.
And I was on.
No, it's all. It's always Slayer.
No.
Yeah.
Exactly.
Because it's always been. Clear anxiety about what the distribution of be. In some decisions, I read it as the Nate decision where section 1 comes up, even though they say cost should be irrelevant. And my response to that as a scholar is to say, it should be irrelevant because rights cost money. The right to vote costs an electoral system. The right to a trial in a fair and reasonable amount of time costs adequately resourced judiciary and trial systems and stuff. It's just the water, the money we already spend on rights is sort of the water we swim in. Is when you move out of this sort of liberal democracy to the social liberalism of social and economic rights, and suddenly you think, oh my God, this costs money. Well, so I mean, think of running an election, hugely expensive. So I think rights cost money, and we need a commitment to spend money on them when we put them in the chart. So I have no patience with that. But that isn't to say that I think there is a twofold concern about the cost, and then about judges making governments pay money that way. So there is anxiety about separation of powers, which I would argue is overstated, or at least the anxiety should go both ways. You should be anxious about not fulfilling what you're asked to do as the judiciary under the charter, as opposed to just preoccupied with, stepping on the executive or the legislative toes. So you don't talk a lot about the separation of powers actually compelling judges to do this, and I think we should. But I also think that budgetary decisions, the notion of the pot that's available, how legitimate is it for judges to order redistribution? Those are all key questions, and one is aided in helping judges think about that by also emphasizing that finding an infringement of section 15 still leaves section 1, right? And that's where some of these concerns could play a role, although I would still say, oh my God, why are you only caring about costs when you're talking about the right to housing? Not the right to vote or the right to a trial. I'll say the most recent one, right to trial within a reasonable time. That's a huge drain and redeployment of resources. So, but I'm not sure how. So you're sort of pointing to the kind of beleaguering of social justice assumptions or commitments. Maybe I'm taking you a bit further than this, but the anti-democratic, anti-redistributive commitments of the hard right. And the way in which we're seeing it expressed in all the different forms of media have lost appreciation of this other kind of conversation. And maybe I'm not.
Well, I think it's I think it's hostile to that conversation.
Well, yeah,
Because
okay, well, that, I'm just saying what overstating.
Oh, no, overstating.
And it's bent on doing the net as figures of any political work. So, what that means in terms of the Canadian Supreme Court, I don't think I'd go that far there, but I'm interested. I mean, David's done some great work in relation to the Gosselin case by looking at media reports of Gosselin before and after the decision, and the way in which the decision actually was prefigured by the media and reinforced in really destructive ways, so that our cultural common sense was negatively amplified and confirmed by the Gosselin result. And I'm taking words from you, but I think that the sort of exchange back, the way in which those two fields interact and speak to each other and work, like Margot, an American political scientist, has also talked about, rights as being deeply contingent upon the environment in which they are born, for example. So yeah, it's interesting. I'm not sure how I would take that observation into analysis of the majority, but I mean, think more about it next.
No, it came up specifically. It's rare that if it comes up at all, you're absolutely right, it's a section 1 analysis, but the government's very diffident about raising it. But where I have seen it raised, and it's interesting that they would feel comfortable raising it, is in disability cases, where it's always more expensive. And if you follow the cost argument in disability, you never get accommodation. So we had been quite assertive about the fact that it was irrelevant because rights cost money. If you're expanding rights, you're expanding resources to people who didn't have it before. It's expensive.
Well, one of the things I'm wondering is that it's like one of the radical elements of liberal legalism is its consistency, right? Is that, well, if you're gonna say this is a principle, then it has to apply equally to all that we're recognizing under this category. And I'm wondering if it's like that running out of gas when the rubber hits the road, it's easy to be redistributive when you have a surplus economy. But when things start shrinking and when you have more anxiety about your political futures, or even just the temporality horizon in terms of the future becoming much closer than we thought it was originally, as fires rage and waters swell. That then when you face what it means to be really fair, substantively fair, it becomes a lot harder. And I think like maybe judges, it's easy to have a robust constitutionalism when you could say that comfortably. But when it involves having to say, well, no government, you need to be fair in the way you're redistributing. And then you start shrinking away from that. I think that's not what the judges necessarily are doing distributing, it's whether they can insist on the.
Yeah, no, I get what you're saying. I guess that's a conversation to be had about how much judges are reacting to and reading popular culture, political, the discussion around political economy issues, and I'm not sure. I don't know. I mean, I think this sort of ideological bent of classical liberalism, and I will say neoliberalism as well, that I think is part of some of the judges in the majority in Sharma, speaks that way to state resources and to state action, the idea of an active state regardless of the economies. And so I would say that's one feature, but how much they're reading the room as well is interesting. How much they're reading the room as opposed to putting furniture in a pre-existing room, whatever you want to go with those images. So I think the reading of the room is a question that's probably less straightforward than maybe how you're framing it is, but I don't know. It's really interesting. Thanks.
So I have one sort of, I'm going to take the moderator's prerogative and ask the last question because then I think we have to wrap up, but it doesn't require a long answer because I think it's kind of a bit more of a simplified sort of analysis, and that is that these cases, and you alluded to it before, there is this criminal law context where there's section 15 that's really not broken through in the criminal law context. And so Sharma was squarely that, CP was squarely that. And you add to that with Sharma the issue of race in the criminal law context. And so that would persuade someone like, in Sharma, it would persuade someone like Justice Muldaver to go over to that side, for example, I think, because of the prospect of once you really grapple with equality rights. And we saw it a bit in cacophonous in the debate between the majority and the dissent, where the argument was around equality in terms of jury selection and jury representation. But again, the criminal law context, which is really, I think, I just wonder if that's really kind of one of the more practical motivating reasons for the decision, or allowing some of those who were more less likely to be supportive of substantive quality to win over more into their camp.
I think that's a really important observation. And I think it's the criminal law context making a difference in a couple of ways, because the criminal law is very worked out, articulate policy system with lots of interconnections. I mean, so in CP, the conclusion was that it actually was kind of beneficial. There wasn't, and here there's a sense that it's not really clear that there's a distinction being made that's harmful, right? There's no data that shows it, and we kind of aren't going to go there in terms of common sense. So this idea that the government has a carefully thought out and complex policy structure
that they're reluctant to disturb and impose certain kinds of conditions on us in some way. And that I think is an important piece of the context for the majority, very different from the context that emerges as sort of the lens through which the issue is looked at, the treatment of Indigenous women from the dissent. So yeah, I think that that's really important, and I think I need to be clearer about that when I talk about the context as this the lens for the majority, and in the context that is the lens very different for the dissent. Yeah, thanks.
So I'm gonna call our discussion to end. It was a very lively discussion, and thank you for this
Pleasure.
wonderful.